Please be seated.
During the past half an hour, I received 3 notes from the jury. One note was in the form of in effect, a letter, a long letter of sort, from a juror that says, "Judge, I understand the position of the court, but I cannot, with good conscience, consider a guilty verdict. I respect the position of my fellow jurors, some of which oppose my position. I expect those who hold opposing views not to change their minds, because I see them as good, honest people. Therefore, I regret to say we may never reach an unanimous decision. As you stated, we must follow the instructions you have given us and the law. We all struggle with the death of a man and with all that has been put before us. I still cannot, without a reasonable doubt, convict the defendant. At the same time, my heart does not want to have to tell the Scott family that the man that killed their son, brother, and father is innocent. But with the choices, I cannot and will not change my mind." That came not from the foreperson, but from a juror. The foreperson then wrote, "It's just one juror that has the issues." And then the foreperson wrote, "Need to leave, that juror needs to leave, he is having issues. Thank you, sorry for all the notes." What says the state?
Sure, the defense doesn't want to take a verdict from less than 12, and that would be our only option.
What says the defense?
To be honest, given the album charge, they can make a decision. I don't think there's a choice.
As I stated earlier, most of the notes have been inartfully written. I've read some of them clearer than they have been on paper. But the note says it's just one juror that has the issues. And of course, it came along with the letter from the juror who says he cannot convict. The question is whether the wording of this note is just one juror that has the issues. Is that a declaration by the jury that the jury is hopelessly deadlocked? Or should the court get a clear declaration from the jury on that issue? A clearer declaration on that issue.
I don't know of any reason that a foreman would know to say we're hopelessly deadlocked.
Well, that would be the question I would pose to the foreperson to make that declaration if it should be done.
I don't object to you doing that.
I have more experience than I think.
Well, generally, we would get a letter saying that, Judge, we've deliberated some more and we still can't reach a verdict, as opposed to it's just one juror who has the issues. So I'm going to have the clerk go and have the jury foreperson let me know with clarity whether or not the jury is hopelessly deadlocked, and we'll sit right here. Typically, the jurors don't send out letters indicating their numerical division, but based on the manner of these notes and seeking to have counsel fully informed, just read what I received as I've done with all the other notes. The preference certainly is for jurors not to indicate a numerical division, and I often tell them not to do so when they send a note, but that didn't make it to this instruction. But assuming that they are, raises a couple of other questions. Bond is up when the case is called for trial. The bondsman indicated that they were staying on the case through the trial, so it has that implication. And also, knowing the numerical division of the jury, have the parties attempted to in any way resolve the case? Or now knowing the...
We just found out like 5 minutes ago.
Yeah.
The division in the case. I don't think it would be appropriate for us to discuss any attempts to resolve the case in open court in front of the media and everyone else. But certainly if this does in fact end up being a hung jury, and if the jurors are willing to talk with us later next week, we'll want some insight from them. I don't want to say any more about attempts to resolve the case other than there have been attempts in the past.
No.
And I don't know if we can move forward with that or not, and I think this jury may have some insight for us in that regard.
All right, Mr. Savage.
Solicitor and I get along quite well despite the experience in the last 5 weeks perhaps, but we're not the only ones involved. So just the people in this room are 2/3 of the situation.
All right, very well. In regard to the bonding issue,
Judge, we contacted the bonding agency, and they were going to check their agents for an insurance carrier, and I don't know that we have heard back from the carrier. We have approval from the local agency. This is saying that they're just still communicating with the surety. That was at 4:12.
civil case. So you do not have any single note. And we'll be at ease for waiting on further work from the jury. Yes. No. And I'll let them know they're free to discuss the case with anyone. Yeah, I'll give both sides an opportunity. Yeah, and I need to certify that they're staying on the